Assalamualaikum warahmatullahi wabarakatuh. And hello doctor. My name is Muhammad Halmi bin Kamil and my metric number is 193466. So for my oral video, I will talk about the role, function and power of the industrial code. So for the long title of the Industrial Relation Act 1967 Act 177, which was amended by the Industrial Relation, prescribes the following: an act to promote and maintain industrial harmony and to provide for the regulation of the relation between employer and workman and the trade union and the prevention and settlement of any difference or dispute arising from their relationship and generally to deal with trade dispute and matter arising therefrom. So, we're going to the role of the industrial relation. There are three roles for the industrial relation, which is uphold social justice, to act in accordance with equity, good conscience, and substantial merit of the case. And then for the last one is to creating a harmonious industrial environment through the process of arbitration and the decision of the court award consistent within Industrial Relation Act 1967. So, power of the Industrial Code is the Industrial Code is a creed of statute. The Industrial Relation Act 1967 is power are derived from provision of the statute, which are the rule of the game, and the Industrial Code has to decide according to this rule. The power conferred upon the Industrial Code have the force of law behind it and are not accessible by reason for the expression vested in it. In other words, the Industrial Code has to function within the limit imposed by the statute that create it and to act according to its provision. For example, like in the case Mostek Malaysian Sendirian Berhad Penang versus Cik Aniza Yaakob 763 Penang 1986. So, in the case of Dunlop Estate Berhad versus All Malayan Estate Staff Union 1980, Muhammad Azmi J had the following: in my view, having regard to the principle enunciated in the case cited, the Industrial Relation Act being a social legislation enacted with the prime object of attaining social justice, industrial peace, demand, practice, and realistic interpretation whenever necessary for the purpose of maintaining good relationship and fair dealing between the employer and workers and their unit and their trade union, and the settlement of any differences or dispute arising from their relationship. So we're going to the function of the Industrial Code. So the first one is to hear and hand down decision or award in industrial dispute refer to it by the minister or directly by the parties. And second one is to grant cognizance to the collective agreement which have been jointly deposited by the employer or trade union of the employers and trade union for the employees. So we can see in the case of Hotel Malaya Sendirian Berhad and Anna versus National Union of Hotel, Bar and Restaurant Workers and Anna 1982. Raja Aslan Shah, CGM, described the function of the Industrial Code as follows. It exercises a quasi-judicial function. It gives a full reasoned judgment in the nature of award. Section 30 in function comprise an investigation of the case and analysis of the fact, finding of the fact, and lastly, the application of the law to those findings. So we're going for the type of cases here in the industrial court. So for the first one is industrial court dismissal of workmen which have been referred to the industrial court by the minister. Trade dispute between trade union of employer and trade union of workmen which have been referred to the industrial court. Application by any party bound by an award or collective agreement for the interpretation, amended variation thereof. Application made by any party bound by an award to refer to the High Court on question of law. Next, complaint of non-compliance of an award or collective agreement. The next one is cases of victimization in connection with trade union activities. The industrial court is armed with the jurisdiction to decide upon complaint of dismissal which are alleged to be without just cause or excuse. The industrial court may award the following remedies. First one is reinstatement of the employer concerned. Then second one is monetary compensation in the form of back wages. So we go into the basic of appeals against industrial court decision in the High Court. The industrial court would exercise its discretion whether or not to refer certain question of law to the High Court for determination. In Section 33A, bracket 1 of the IRA 1967 provide the following. Where the industrial court has made an award under Section 30, bracket 1, IRA 1967, it may, in its declaration on the application of any party to the proceeding in which the award was made, refer to the High Court of question of law. The first one, which arose in the course of proceeding. Second one, the determination of which by the court has affect the award. Third one, which in the opinion of the court is of sufficient importance to the merit such reference, and the definition of which by the court is in the opinion of the court sufficient to merit such reference. So the High Court supervisory jurisdiction. Judicial review jurisdiction is distinguished from the appellate jurisdiction of High Court. For example, we can see in the case of Tanjung Jaga Sendirian Berhad versus Minister of Labour and Manpower and Anno 1987. Clearly provide that judicial review is concerned with the decision-making process of the tribunal as opposite to the decision made by the tribunal. At the review level, the High Court will only look at the decision-making process as opposite to the merit of the case. In the event, the error of the law goes to the issue of jurisdiction. The High Court will then intervene. There may be instances wherein the High Court make an order quashing the award of the industrial court, and the case is then remanded back to the industrial court for a fresh award in accordance with the law. So, in the second case, we can see at Pembinaan Asbudin Manufacturing Sendirian Berhad versus Sambi Pillai Si Wak Nanam Anchor 1990. If there is an error or law on which the award of the industrial court is found, such error whether of interpretation of or otherwise must necessarily be without jurisdiction or in excess of jurisdiction. Any decision in any award based on an invalid interpretation or construction of the law must surely be a nullity, and this must be construed as a nullity resulting from the industrial court doing or failing to do something in the course of inquiry, which is of such a nature that its decision is nullity, as referred to by Lord Reed at page 171 in a minute case, or the court having asked themselves the wrong question, as referred to by Lord Diplock at page 187 in the Record Communication. So, we're going to the view frame in Industrial Code Award. Back wages. Pursuant to the section 30 bracket 6A of the IRA 1967, the second schedule of the Act, in the event the Industrial Code Award back wages does not exceed 24-month back wages from the date of dismissal based on the last gross salary of the person who has been dismissed without just cause or excuse. As for a probationer, back wages would not exceed 12-month back wages from the date of dismissal based on the last drawn salary. In the event of the post-dismissal earning, a percentage of such earning to be decided by the court should be deducted from the back wages given. Any relief given take into account contributory misconduct of the workman. For example, we can see at the case of Suhaila Sulaiman versus Weiger JB Sendirian Berhad at 2008. Back wages based on climate last drawn salary but limited to 24 months. And the second one is Dr. James Alfred Sabah versus Koperasi Serbaguna Sanya Berhad Sabah NO 2001. The industrial court, in assessing the quantum of back wages, must take into account the fact, if established by evidence or admit that the workman has been gainfully employed elsewhere after his dismissal. The industrial court is aimed with jurisdiction to decide upon complaint of dismissal which are alleged to be awarded just cause or excuse. The industrial court may award the following remedies. The first one is reinstatement of the employee concerned, and the second one is monetary compensation in the form of back wages. So that's all from me, doctor, and thank you for watching my video. Assalamualaikum, and thank you, doctor. Bye.